Today, incestuous relationship is barred in heterosexuals. Prohibited degree is barred in heterosexuals. My lord, any other, my lord, three people coming together, the argument Mr. Sibal gave is barred in heterosexuals. My discrimination argument will fall flat. An 1872 statute, my lord, which had an onerous condition that you must give up your religion. The 1872 Special Marriage Act, which was repealed by the 1954 Special Marriage Act, said for those who do not profess Hindu, Buddhist, Christian, Sikh religion, because you have to give up the religion, my lord. Now, in 1950, when the Constitution came into force, marriages were by personal laws. Entry 5 in list, my lord, 3, the field of legislation was demarcated. If, my lord, an interfaith couple had come to your lordships and said, I don't want to give up my religion, I want the same status that people who have gone the religious route and have come in an association of marriage are being given by the state in all their activities, my lord, in terms of pension, insurance, and all those things. In my respectful submission, your lordships would have found that right and found a positive obligation. Found a positive obligation in commanding the state. Your lordship would not have turned the interreligious couple at the door and said, there is no legislation today. The legislation says you have to give up your religion, the 1872 Act. Your lordship would have found that to be unconstitutional, number one. And your lordships would have recognized their right to marry without giving up their religion, my lord, in an interreligious marriage. Today, my lord, after Navtej, in 50 also, my lord, this 377 had considered this association as unnatural. The natural association was of a man and a woman cohabiting without force. But this was unnatural. Consensual cohabitation was unnatural. So it could not have recognized. They would have had a valid defense in saying it's an offense. It became natural, purely natural. With Navtej having, my lord, exorcised from 377 the penal part of the provision. Now, my lord, in this scenario, if, my lord, marriage is the ultimate union as has been developed, my lord, in the jurisprudence that we have placed.
Nathan,
yes.
Now, no doubt this is a very this hypothesis is very attractive to dwell upon in a 2023 court. But the fact remains that in the 1950 court, viewed fundamental rights essentially very differently. With A.K. Gopal and etc.
We
have to transpose ourselves back then. No, we had a far segregated or fragmented view of fundamental right. What you're doing essentially is placing that situation and transposing it to the present context.
My lord raised that argument of what could have been the situation between 50 and 54. It's a very important, my lord, question.
It's not just interfaith. Till 1946, even inter-caste marriages were prohibited.
So, my lord,
the 54 Act went beyond religion. It actually demolished all those other barriers. So in that sense, that statutory intervention brought that about.
Now,
so both parts, you may be right. Now the question is to take forward that hypothesis. How do you bolster it?
Yes.
With which kind of precedent do you bolster?
Yes, my lord. Kindly have a look at my note.
You are relying on that Narula. You're relying on Salmon.
I am relying on Salmon for, my lord, right and correlative duty. Yes, I am relying on, my lord, the positive obligation judgments.
And you're relying on Cooley's
constitutional limitations. I am relying on, my lord, what will of the people is. It is argued that will of the people in the context of a referendum. Will of the people, your lordships have said, is the constitution. Your lordships in constitution benches have said will of the people is already reflected in the constitution.
We're going to rely on those passages in B.R. Kapoor also.
B.R. Kapoor also, my lord. Will of the people. I have even gone a step further and argued in the alternate. Assume it is a privilege they are extending. Even in a privilege, your lordships have said you can't discriminate. In the most, my lord, noxious of trades,
Yes, you are right.
if you, now what is this, my lord? Is it a right they confer by exercising their duty?
Nandraj Jaiswal.
Nandlal Jaiswal, I quoted Nandlal Jaiswal in the note.
You did.
Now, my lord, let me assume by forming statutes, by regulating it, they are giving some rights, my lord, or deem it as a privilege. In both, argue on both prongs, my lord. Can you now discriminate? Can you now discriminate, my lord, is the question. So the real question before a lordship is, subject to correction, my lord, the right to marry, yes. Is there a duty in them to recognize this association as a marriage and extend the privileges which heterosexual couples have, my lord, come to enjoy? And if your lordship asks that question, my lord,
Not to sound a spoiler, just one question. Then in that
no,
case,
my lord, it's
the
only your lordship's, my
next
lord,
case would, the
my lord,
next
queries which bring out.
question would be,
Yes,
what all relationships would you locate the duty?
yes.
In the case of a live-in also, then you will say that the law should cater to every kind of relationship.
No, my lord. My lord, that is an argument addressed. Incestuous relationship was argued. I'm just
Will
giving
not
an
take it
illustration.
to that extreme.
Three people coming together was argued. My lord, 1 minute, I can't. Whatever you are giving the heterosexual couple, there I am putting it on discrimination. Today, incestuous relationship is barred in heterosexuals. Prohibited degree is barred in heterosexuals. My lord, any other, my lord, three people coming together, the argument Mr. Sibal gave is barred in heterosexuals. My discrimination argument will fall flat. But if you are extending, my lord, a certain right, call it privilege, can you then, my lord, post Navtej, when you have called this relationship natural, when it is no longer unnatural, and when your lordship say we have to be put on even platform, don't they have, my lord, as Saman says, if you have this much, they have, my lord, a duty which they have extended to, my lord, a set of heterosexual couple.
Mr. Vishwanathan,
Yes.
I mean, just as a matter of jurisprudential curiosity, I dealt with this argument in my in Aadhaar. The only problem, it's a dissent. And if you see my Aadhaar judgment, which is 2019 1 SEC, it is at 664.
We are given it.
There's a segment called Development as Freedom.
Yes, my lord.
And where, after citing Amartya Sen and Martha Nussbaum and adverting to the capability theory, I referred to Henry Shue. And I say Henry Shue suggests that rights give rise to corresponding duties.
Yes, my lord.
These duties include: 1, a duty to respect; 2, a duty to protect; and 3, a duty to fulfill. Just see this. I mean, just
No, my lord, that is exactly, my lord, we should have
just
placed
see,
that.
do you have that?
We
by way?
edit in
Or
the
we can-
context.
I can share it with you if you
My
want.
lord,
The judgment is at, just see, at page 790. 790.
my lord, we are getting the book.